I grew up in Lagos, Nigeria. I came from a close-knitted family, even though I came from a poor family. But they gave me education with the instruction that this is the tool that will help me to dig my way out of poverty and ignorance. I came without a dime in my pocket. All I had was big dreams, determination to succeed, and the resilience. So coming from another country gave me that insight to be able to understand and deal with people from different backgrounds.
I was walking into Kroger to pick up a prescription for my mom. Upon approaching the pharmacy, I slipped and fell in some liquid. I went to see my regular doctor, and that is when I knew that there was more going on from that fall. I then called Mr. Olawale, talked to him and let him know what was going on. I could just say that he's very professional and knowledgeable about what he does. He's very passionate about what he does, and he cares about his clients. I felt like I was a part of the Olawale family.
The goal is to make sure that our clients will leave feeling that someone gets them, knowing that someone was able to be the voice for them.
We needed an attorney because we needed somebody who understood the relationship between our case and the law. We had been through 4 different lawyers. We were very desperate. We knew from what we had heard that Emmanuel Olawale was the man, who could take us through that experience and see us through and give us the kind of outcome we were looking for. For him, your case is personal. He gave us hope. He gave us encouragement, and we knew that we had found the right man that would see us through.
Just know that when you're coming through the door, you're coming in through a place where you will be accepted and welcome as family, where you'll be seen as a person. At the Olawale Law Firm, we get you. We understand you. Trust us. Welcome to another enlightening episode of Legal Angle with Emmanuel the Law Olawale. My guest today is all the way from Louisiana. He's a criminal defense attorney, one of the best that I personally know of, an award-winning criminal defense attorney. His name is Keith Whiddon. Welcome to the show, Keith.
Thank you so much for having me. This is something that it's kind of like a dream come true, or maybe I visualized it and thought about being on this show ever since you first told me about your show. Whenever we met, quite a few months back. So it's sort of a small dream realized. So.
Yeah, we were just talking about that shortly before we signed on. I remember just seeing you at the summit in Atlanta, or was it like in November? You were in line and you were just like, you just shouted my name out. Like, I want to be on the podcast. And I was like, okay, we can arrange that. And here we are.
Right. Yes. So, and heck, that's only a few weeks ago now. So
yes, a few weeks ago. Wow, thank you. I'm glad to have you on the show.
Well, like I said, I'm very excited to be here. Very excited to be a guest on the show.
Thank you. Can you tell us more about yourself? Introduce yourself to our audience. Let them know who Keith is.
Yeah. So I am Keith Whiddon. I'm a criminal defense lawyer in Monroe, Louisiana, with a special emphasis on my practice is on DWI defense. And we also do, of course, all your other criminal defense cases. And then the other thing that we do at my office is I'm co-owner with a great friend of mine and someone that Emmanuel knows as well, Devin Jones. We co-own EraseMyArrest.com, which is a statewide expungement practice. So if you have, number one, if you have a pending criminal case, of course you want to look me up and give us a chance to see if we can provide service to you. And then if you have an expungement in the state of Louisiana, by all means, go to erasemyarrest.com and fill out the form and get in contact with us. But as for me, I grew up in very rural Louisiana, graduated from a very small public school at this, but there were only 26 of us. Upon graduation, as soon as I graduated, I moved to where I'm at now, Monroe, Louisiana, about 3.5 hours away. Completed college, then went to law school in Jackson, Mississippi at the Mississippi College School of Law. Graduated there, and whenever I was in law school, I thought that I was going to be sort of the plaintiff's lawyer, the car wrecks and toxic torts, mass torts. It's kind of what I thought I would do, but I like to tell people, especially whenever they ask, well, how did you get into criminal law? How did you get into DWI defense? And the fact of the matter is it more or less chose me. If I could describe my legal career as briefly as possible, graduated law school, went to work for a firm like a lot of people do, and basically 1 year into being there, they walked in and said, hey, Keith, look, it's just not working out for us. We're going to have to let you go. And so that was fine. Packed my stuff up, left, and bounced around for a couple weeks, and finally found a place to land at Legal Aid. And at Legal Aid, I represented children that were in the foster care system. And that in itself was a really great training ground for what I do today, because I saw basically every judge and prosecutor and defense attorney that is in the northeast corner of Louisiana. They knew me and I knew them. So that was a really great training ground. It was also a great place because a local attorney that I saw at least once a week, had these terrible heart problems. And he knew that he was going to need a transplant. And he was doing bankruptcies at the time, but he also had a public defender contract to represent mothers in the foster care system. And one day he said, hey, Keith, I have these really bad heart problems. I'm going to need a heart transplant. If you moved into my office, I'll teach you how to do bankruptcy. I'll get you a contract with the public defender's office so you can have a little bit of money in your pocket. Would that be something that interests you? And I said, yeah, that'd be awesome. I would love to do that. So I left my job at Legal Aid, moved into the office that that lawyer was into, expecting to start off a partnership of sorts. Turns out that he had already been in the hospital for at least a week whenever I moved in. And then, moved into the office on April 15th, and he passed away on May 1st of 2015. So all those things of me having someone to train me up and teach me how to do bankruptcy and teach me how to do this, that, or the other kind of went out the window. And the landlord for the building was also a lawyer. He was actually my misdemeanor supervisor. And this was about, 2-3 weeks after that lawyer had passed away. Me and the lawyer downstairs, it's early in the morning, 7 o'clock, and we're just sitting there and talking about cases and work and things like that, drinking coffee, and he just looks at me and says, well, Keith, you're already moved in upstairs. You want to just rent the whole thing? And I just kind of thought to myself, do I even have a choice? And so I said yes, and that was the start of my legal career as a solo practitioner, really. And how I got to where I'm at today is that every year in practice, at the beginning of the year, I've said, I am never doing another one of these cases. And so starting out, it was, I'm never doing another child custody case. I'm never doing another wills and successions and estates case. I'm never doing another divorce case. And then I'm never doing another workers' compensation case, which was crazy because that's what I had done at the law firm. I thought I was pretty good at workers' compensation, but it just got to be, the juice was not worth the squeeze. And so I cut everything out until all I had left was the criminal defense stuff. And so it wasn't me choosing criminal defense. Criminal defense and DWI defense chose me because it's what interested me. It's what I thought I was good at or think I'm really good at, and I think that the results I get from my clients say that I'm really good at it too. And so criminal defense and DWI defense chose me. So,
wow, you found your path. What was it like to grow up in a very small, you say you grew up in a small town and having to go to a school that only has 26 kids? What was that like?
Well, and my graduating class was of 26 people. There were about 500 total students, K through 12. So kindergarten through 12th grade was around 500 people. And to top it off, my mother was a high school teacher, and for the majority of my time at that school, my dad worked at that school as well. My dad started off as the basketball coach, took another job as a basketball coach about 45 minutes away, and then moved back to my school whenever he became an assistant principal and then principal. So I had both parents at my school, or at the school that I was attending, for most of the 17, or no, not 17, most of those 13 years. So, but growing up in a small town was, Devin made a joke that I normally get charged by the hour to talk about where I grew up, but it was, I'll say that it made me the person that I am today, for better or worse.
So I guess
I knew from having lived there what I wanted to be and also what I did not want to be, being raised there.
Did you have an idea that you wanted to become an attorney?
No.
Yeah.
No, I had no idea that I wanted to be a lawyer. Whenever I was in college, I was in English education. My parents were educators, and I was really good at reading and writing and enjoyed reading and writing, and I enjoyed being around people. And so it was kind of like, yeah, I'll go to English education. I'll get a master's in English, a PhD in English, and I'll teach English in college. That was sort of the grand plan. And then one day, my mom had come up to help me get all this stuff out of my dorm room around finals, and she and I went out to eat lunch. And we're there eating lunch, and she said, Keith, you like reading and writing, and you like being around people and helping people. Have you ever thought about law school? And my answer was, no, not at all. I don't think I'm smart enough to go to law school. But I started looking into it, and then sat for the LSAT. And after that first result in the LSAT, I scheduled another LSAT and got some study materials, and the rest is history. So from about my sophomore year of college, I knew that I was going to take the law school route. I still thought I was going to be a law school professor, but that isn't quite in the cards for me at this point in time. Maybe someday, but not today. It's not really a goal of mine anymore. I really enjoy being a lawyer, a DWI defense lawyer, and being a business owner and entrepreneur.
Yeah, it makes sense that you saw yourself as teaching law since you grew up with your mom being an educator. So it's just like following your mom's footpath.
Absolutely.
And, you talked about being hired for your first job and being let go. What did that feel like?
That was a real kick in the gut, because now I will say this. Clearly, they did me the biggest favor that I could have asked by letting me go. Because even at 6 months in, because I was doing workers' compensation defense, and I remember after about 6 months of it, I looked in the mirror and I just thought to myself, I did not go to law school for this. And so luckily they got me out the door, before I spent 2 years or 5 years there being unhappy. But at the same time, it was, everyone's going to be so disappointed in me. I worked so hard and I did all these things, and now I can't provide for myself, and I had at the time I was married, and I had a young child, and it was, what am I going to do? How am I going to provide for these people that are counting on me? What are people going to think about me? Am I going to be able to get another job? Or is this firm going to more or less, put the scarlet letter on me, if we want to reference literature? How am I going to recover from this? And bouncing around for 6 weeks, thankfully I found a friend of mine from law school who needed some writing and research done. I was able to do that and rebuild some confidence while I looked for another office job. So, but it was 6 weeks of of almost fear and doubt, because, like I said, I'd gone so far, felt like I'd done everything I was supposed to, and it turned out I was just trying to fit a square peg into a round hole. Just wasn't meant to be. So
You never felt at home in that law firm.
that's for sure. Yes, I never felt like it was a fit.
And when you left the law firm, you said you joined the legal aid.
Right.
Yes.
I put in applications everywhere. So yeah, those are the people who call me back.
Who called you back? And did you take on criminal cases while you were working for legal aid, or was it just general practice?
No,
Divorces
so
or whatever comes in.
No, so at legal aid, I was not allowed to have an outside practice. I was given the cases or I could only work the cases that were assigned. And at the time, and I think it's still the case today, the state of Louisiana has a contract with the legal aid office where the legal aid office furnishes an attorney for a child that is in the foster care system. I know in other states there's guardian ad litem and things like that. I was more or less the guardian ad litem, except for the fact that, again, the state of Louisiana appoints a lawyer to represent the child that is in foster care. And as the lawyer for the child, it was my job to either represent the express interest of the child or the substituted interest, what I believe would be the child's wishes in the event that the child could not express his or her interest. And it didn't matter if the child was 17 or 7 months. If I had a child at 7 years old that told me, and this was actually a real life event, if I had a child at 7 years old or even 4 years old maybe, that said, no, I want to go live with my mom and my dad again, no matter the circumstance that they came from, no matter what the best interest of the child may be, no matter what DCFS says or Child Protective Services says, and if you really want me to spill my guts on some stuff, you can get me started on Child Protective Services. But anyway, we don't have to stay on that one. No matter what anybody else in that room says is best for that child, I don't represent the best interest of that child. I represent that child's express interest. So
you're the child's attorney.
Mm-hmm.
And you fell into criminal law practice. When did you realize that this is what I was born to do, or this is what I love to do?
So I enjoyed being the misdemeanor public defender. That was part of the start. Criminal law just clicked for me. It all made sense. And then there's the other part where I don't, more than criminal law, I don't really have never been a prosecutor, don't have really any interest in being a prosecutor, prosecuting cases, because at the end of the day, I represent somebody who has a heartbeat, who has a family, who has people that care about them, who love them, who needs to be back home so that way he or she can tend to their family, can earn an income, things like that. That's the difference and I mean, don't get me wrong, I understand that prosecutors represent victims of certain crimes, but there are also a lot of crimes where there is not a definable victim. And so at that point, what do you represent? You represent the state of Louisiana. And the state of Louisiana is, it's four borders. It doesn't have a name or a heartbeat or anyone that cares whether or not it goes home at the end of the day or it comes home at the end of the day. The state of Louisiana is just, it is what it is. It's not a person. And so I think that that's something that's very different about what I do is I represent people. I represent a person. And that's kind of even our firm attitude where we fight the charges, but we treat or we care for and we respect the person.
Thank you. You respect the person. And on that note, let's take a short break and watch this video.
The reason why I chose criminal defense isn't so much that I chose criminal defense. Criminal defense chose me. I love the fight.
I get to play a little bit of mad scientist because when it comes to police work in general, there's psychology of the arresting officer, psychology of the person being arrested. There's knowledge about the ins and outs and your constitutional rights. So that way you know where the weak points are and how to attack them.
I was working at this bike shop. A few parts come up missing right about the time that I had quit. The time I left, they hit me with the felony charge. When I first hired Keith, I was scared. He comforted me. He told me exactly what to do. He said, we'll work through this together. When we got into that courtroom, I think he said 4 words and the judge dismissed everything. The huge burden that was on my back has now been lifted. Would I recommend Whiddon Law Office? That'd be a very highly strong yes. He's virtually a silent assassin.
No one should be judged whenever they are in the middle of what is the worst time and the worst position in their entire life. I don't judge them based on what the situation is. I don't judge them based on what some third person has accused them of. What we do is we give them that fighting chance that they didn't know they had whenever they think that they are backed up against the wall. We help them fight back.
I reached out to Keith because my son was being accused of a double homicide. I was so scared and frightened because I know that's not his character and that's not who he is.
My biggest fear going through this was the justice system, honestly. Whether I was going to get the proper justice or whether I was just going to be another statistic. Because what it looks like is not what it actually was. When I first talked to Keith and told him everything, he said he believed me and he was going to bring justice to me.
It made me feel secure. It made me feel like I really got a lawyer that's for justice for my son. I will absolutely recommend Keith Whiddon Law Firm. He cares about his clients, and that's hard to find these days.
This is what I want to do. This is the only thing that I do. I don't do divorce work. I don't do child custody work. I don't do injury work. I do criminal defense. At Whiddon Criminal Defense, we believe that after the arrest is made, the fight has just begun, and we give our clients every fighting chance.
You give your client every fighting chance, and your client calls you that silent assassin. Wow, powerful testimonies. Now, tell us, what is DUI or DWI?
So DWI is what we commonly refer to it in Louisiana. If you want to be technical about it, the book calls it OWI, or operating while intoxicated. Essentially, you are under operation of a motor vehicle, which is more than probably isn't the right way of saying it, which includes more than just driving. Is the engine turned on? Is the radio on? Are the keys in the car? Things like that. Or I should say keys in the ignition. Because if you are in any way in operation of the motor vehicle, then now that element of the crime is satisfied. So operation of a motor vehicle, which is more than or includes more than just driving, or is not just driving, I probably should say, is one element of that crime. The second element of that crime is intoxication. Intoxication can be proven by a chemical test. So that's going to be your breathalyzers whenever you have a blood alcohol content that is 0.08 or higher on a valid machine that has been standardized and certified by the state of Louisiana. Or it may be through testimony, officer observations, the officer roadside tests. Those are basically ways where the officer can satisfy those things. And then there's also other chemical tests, whether it be by urine, blood, etc., where an officer could, or I guess a prosecutor could prove or attempt to prove proof beyond a reasonable doubt that the defendant was intoxicated at the time that he or she was in operation of a motor vehicle. But essentially, at the end of the day, it's two things: operation plus intoxication.
Operation plus intoxication. And what is blood alcohol level?
So blood alcohol content, it's exactly what it sounds like. It's how much blood is in, or how much alcohol is in your bloodstream, and it can be measured by the breathalyzer. A lot of states allow for a PBT, or a portable breath test, to be used at roadside, but that is merely for the purposes of making an arrest decision by the officer. It is not to be used as evidence in court. Then the other thing is going to come down to the actual desktop machines. Those are the ones that are going to be generally admissible into court. Those are, and the way that those things work is that inside of that machine is a sample chamber, is what they call it. And it's in the shape of a tube. It's, 12, 13, I think in the Intoxilizer 9000, which is what the state of Louisiana uses now. It may be as little as 8 inches long. And what happens is you blow into the tube. And then that your air that you have blown into the machine goes into this tube that's inside the machine. And on the opposite end of that tube, there is a spinning wheel with red light being pushed through. Okay, and so and then there's a receiver on the opposite end. And what that machine is looking for is basically the more light that gets through, the less intoxicated they are. The less light that is able to be picked up by the receiver is how that spits out a number. Less light, more intoxicated, or higher blood alcohol content, I should say. And so that machine uses the amount of light that is getting through the sample chamber to spit out a number. And when it comes to the algorithm or the formula, whatever it may be that at least CMI and Intoxilizer uses, or for the Intoxilizer 9000, those computer programs, that's all proprietary information. We don't know what it is, what it says. Despite how many subpoenas we send or public records requests we send, the nice people in Kentucky at CMI still do not want to give me, much less any other lawyer, the information on how their machine really works. And by the way, a lot of people will argue with you and tell you that that is an instrument because it measures things, but it's a machine at the end of the day. So it's a machine. It's plugged into the wall. It relies on computers, things like that. I've never seen anybody plug in a tape measure to make it work. So if you want to tell me that it's an instrument because it takes measurements, then also show me where you plug in your tape measure.
Yes, interesting. So what's the difference between an instrument and a machine?
Again, it's in my mind it's not an argument to be had. It's that the state of Louisiana, or the state of Louisiana's experts, want you to believe that this machine is foolproof. And it's foolproof because why? Because the state of Louisiana tells us it is. But again, they can call it an instrument because it takes measurements, but if I pick up a tape measure or a ruler, it's going to be the same no matter what. I'm not going to have to have someone come in and calibrate it every 6 months. It's not prone to error. I don't have to have it plugged into the wall, things like that. That the Intoxilizer relies on computers and on the data that the officer inputs into it. And it's subject to manipulation by the way that an officer may instruct someone to blow into the tube, because we've all seen the videos if we're adults. The officer tells you to blow into the tube and blow as hard as you can. Well, the reason why is because at the very bottom of our lungs, we have these little hairs. And I'll probably mispronounce it, but they are, I believe, called alveolar hair, something along those lines. But anyway, those little hairs actually hold alcohol. And so the officer more or less wants you to stir up those little hairs in the bottom of your lungs, so that way more alcohol is released through your lungs into your breath and out into the machine. The other thing that you have to consider is that an officer must conduct, in the state of Louisiana, a 15-minute observation period. And it's general observation, it's not direct observation, which means the officer can be off doing paperwork or something like that to the side. But what's the purpose of an observation period? Well, the observation period is meant to purge the mouth of any residual mouth alcohol, any mouth alcohol that may have gotten stuck in your cheeks and between your teeth or things like that. That 15-minute period is supposed to cleanse it. But if that's the case, then how come Texas has a 20-minute observation period? How come Texas is what we call a two-test state, where you have to do 2 intoxilizer tests? State of Louisiana said, oh no, 15 minutes in one test is fine by us. We're not worried about what Texas is doing or anything like that. So.
Interesting. Can a driver refuse to take the test?
Yes, and a driver is under no compulsion to take the test. Now, a lot of people like to yell and scream and cry about the implied consent law, and the implied consent law is a thing. In the state of Louisiana, probably just like any other state in the union, if you refuse to submit to an intoxilizer or other chemical testing, yes, you can face a driver's license suspension. Not doubting that. Driver's license suspensions can be fought. And even if you do not have a driver's license suspension, even if you do have a driver's license suspension, you know, it may not sound like the most practical thing, but you can take a bike to work. You can take an Uber to work. You can cancel your car insurance. You can, take your car and trade it in. And I'm not saying that those are practical solutions. What I often ask people, though, whenever they yell and scream and cry about the implied consent law, I say, okay, would you rather have a suspended license and no conviction, or would you rather have a suspended license and a conviction and, oh yeah, whenever you're found guilty or plead guilty to a DWI, your license is suspended a second time? Which would you rather? Because that's your options in the state of Louisiana. And
two evils.
Mm-hmm. And the fact of the matter is that when it comes to not having a driver's license, people find a way to make things work. Whenever it comes to, but whenever you're facing 6 months in jail, maybe mandatory time if your BAC is of a certain level, you don't really find workarounds for getting out of jail. So, at least not legally.
Yeah. Is there a way for a defendant to challenge the result of the breathalyzer or any of these instruments used to measure blood alcohol content?
Yeah, and remember, it's a machine, so don't get it twisted. It's a machine. But yeah, so yes, there are ways to challenge. The only problem is that machines don't like to talk back very much to me. But there are ways to challenge it. The number one way to go about doing it is the first thing we always check for the certification date. It is statutory law in the state of Louisiana that an Intoxilizer 9000 must be recertified every 6 months by the Louisiana Department of Public Safety and Transportation, I believe, is who oversees that. And if that machine is not calibrated, then now the results are invalid. Other ways to invalidate the machine or the results of the machine are going to be if you can get an observation room video, the observation room being the room where the the intoxilizer is located. And if you get that video and you're able to show that, well, the officer did not do a good observation period, his observation period was too short, or his observation period, maybe he got up and left the room during the observation period. And just so we're clear, the observation period is the time where your mouth is supposed to be purged of mouth alcohol. And it is the officer's job to make sure that during that observation period, you do not burp, belch, or regurgitate, or do something else that would otherwise refresh the mouth alcohol content that you may have. So if the officer gets up and walks out and a client, right there does this thing where they go, we know what that is. We don't need to say what the is. And I apologize to anybody that may have a gag reflex, but we know what that is. And whether or not we see anything after that, we all know what happened. And so what does that mean? That means that while the officer was out of the room, the defendant's mouth alcohol content is suddenly refreshed, but he doesn't have to actually, regurgitate for that to happen. He can do that by burping, belching, or anything along those lines. And even, let's not forget, I know quite a few people that have permanent retainers in their teeth that will hold mouth alcohol, but that's another aside. The best way, short of a machine that's not certified and short of an officer just totally botching the observation room or the observation period, the best way to attempt to get the results of an intoxilizer out are to show that the officer should not have made the stop on the defendant in the first place. It goes back to probable cause. Did the officer have probable cause? And this is where the officer training, where when I talked about in the video that you showed of me, where the officer's psychology really plays into this. This is money right here, because I can fight a case with or without an intoxilizer. I prefer to fight it without an intoxilizer, but even if I do have an intoxilizer, I can fight the case the same way. I just have to go through a motion to suppress to do it. So what I would attempt to do in a situation like that is, if I have an officer that should not have made the stop or should not have made the arrest, we're now at a probable cause issue. And anything that is gotten after that arrest is through the poisonous tree and therefore can be suppressed or excluded at trial. So what do we have to do? I have to show that the officer should not have made the arrest. Well, how do I go about doing that? Well, what led to the officer making that arrest decision? Officers frequently make arrest decisions about DWIs based on their roadside test. The horizontal gaze nystagmus, that's the follow the finger test, okay? Follow the finger, follow the pin, follow the flashlight, that kind of thing. The walk and turn test, walk down a straight line, walk back. And the one leg stand test, hold this foot 6 inches off the ground and count out loud. Those are the 3 standardized tests from the National Highway and Traffic Safety Administration, also known as NHTSA, is what I heard on a commercial just the other day, also known as NHTSA. These are the same people who write who have the click it or ticket billboards. They have a child safety seat commercial that I saw lately. It's those same people. They have written every manual on how to investigate a DWI. And it is the same law, more or less, in all 50 states. There are some states that are not NHTSA states, but for the lion's share of states are going to be NHTSA states. And so that means that the way that you investigate a DWI is the same from New York to California, from Louisiana to Montana. It's the same thing, and the officer has to follow the same training. And these are tests, the 3 that I mentioned, are standardized and valid tests, and they are standardized to this certain way to be done. And if the officer does not follow his training, does not maintain the standard that NHTSA has set out, then the results of his test or her test are not valid. So, whenever you have a situation like this, we filed the motion to suppress. We have the officer in there, and so now we are cross-examining the officer about, officer, how did you do the horizontal gaze nystagmus test? And so I have him telling the court how he did the horizontal gaze nystagmus test. And if he says something that doesn't line up, then I have him commit to it. I say, oh, so you held the stimulus for, if we're talking about the eye test. Okay, so you held the stimulus, you said 12 to 14 inches away, and it was at eye level, right? Yeah, that's how I held it. And that's how you do it every time, right? That's how I do it every time. Okay. And so you would have done it that way this time too, right? Right, okay. And that's the right way to do it? Yeah, of course it's the right way. That's how I was trained to do it. I know I do it the right way. I say, okay, cool. And so then I go to the actual officer's training manual. I have every officer or every NHTSA training manual, I think back to 72, for whether it be the SFST, the Standardized Field Sobriety Test, ARIDE, the Advanced Roadside Impairment and Drug Recognition, or Advanced Recognition of Impaired Drivers, Impaired Drug Driver. Anyway, I forget what it stands for. But anyway, ARIDE, DRE, Drug Recognition Experts, they all have their own manuals. And so I just break out his manual. I say, officer, this is your manual, isn't it? Yeah, I had something like that in the academy. Okay. And you're up to date on your DWI training? Yeah. Follow your DWI training? Yeah. Pass the test to do DWI stops, didn't you? Yes, I did. Okay. And so you know what's in this book, right? Right. You're trained on this book. I was. Okay. Now, officer, I want you to turn to session 6, page 32, or whatever the page number may be. Tell me, how are you supposed to position the stimulus? You hold it 12 to 14 inches away, slightly above eye level. Now, officer, you stated that you held the stimulus at eye level. Is that correct? Yes, that's correct. And you stated that's how you do it every time, right? Yeah. And you say that's how you would have done in this case, isn't it? It is. Okay. But that's not how your training says to do it, is it? Well, I thought I was trained different, but that's not how NHTSA says you're supposed to do it. That's not the standardized and valid way to do it, is it, officer? No, it's not. So can we rely on the results of your test, officer, if you didn't perform the test correctly? I mean, I think you could, but NHTSA says you can't, right? Because NHTSA said that you have to do it this way, don't you? Yeah, that's what they did. So the results of your test aren't valid. No, they're not. And that's what you do. Every time that you find a chink in the armor, and especially whenever you have video, because whenever you have video, you get to see how quickly is the officer moving the stimulus from left to right, because this is supposed to be done in a very calculated way. You're supposed to do it. You know, if you're doing the first phase of the test, first phase of the test is a check for equal tracking and an equal pupil size to make sure that the defendant doesn't have a brain tumor or concussion or something like that. But once you check that eyes are tracking in their equal size, then you're looking at, okay, let's check. That has to be done at a very certain way, very certain distance, and it's supposed to take basically 2 seconds per eye in that first phase of the test. And so if the officer is going back and forth like this, the officer is basically creating nystagmus. And that's what the officer is looking for. The officer is looking for an involuntary jerking of the eye. And if the officer observes involuntary jerking of the eye whenever he is performing this test, he's going to check, okay, positive for horizontal gaze nystagmus. And that's what NHTSA says is 77% reliable. But if the officer is performing this test wrong, if he's moving the stimulus too fast left to right, if the officer is moving the stimulus too slow from left to right, if the officer has the stimulus improperly positioned, then the results of his test are not valid. Also, it's worth noting that there are more than 40 different kinds of nystagmus completely unassociated with consumption of drugs or alcohol. You ask any eye doctor that, and they will tell you that. And in fact, we don't have to ask an eye doctor because guess what? It's actually written into the officer's A-RIDE manual. So that way, whenever an officer, because we get officer training records at our office, we know what DWI classes the officer has been to. If he's been to SFSTs, if he's been to A-RIDE, if he's been to the 2-day refresher course, whatever. We know that. And then, now, officer, there are more than 40 different kinds of nystagmus, aren't there? Well, I don't know how many kinds of nystagmus there are. Officer, you went to A-RIDE, didn't you? Yeah, I did. Familiar with that training? Yeah, I am. I pull out his A-RIDE manual. Officer, this is your A-RIDE manual, isn't it? Well, I had one like that, yeah. Okay. So why don't you turn to, session 3, page 22. Now, does this say how many different kinds of nystagmus are there? There are more than 40 different kinds of nystagmus. Okay. And that's what you're trained on, right? Yeah. Did you forget your training, officer? So that's how you can go about doing that.
Wow, what a great job you guys do in court. Yeah. What happens in a situation where someone is not intoxicated on alcohol, but on a different kind of substance?
So
cocaine, weed, any of those stuff.
So whenever it comes to other substances, that's where the drug recognition experts come into play. Those are the big boys. There are very few of them in the state of Louisiana. And so first of all, but again, you're not always able to call one in. And then they're here in the town that I live in West Monroe, there's one of them that's, regularly out on duty. Really good guy. I mean, I like him, genuinely like him. And he knows what he's doing. He trains people left and right, and he trains really well. He does a really good job at what he does. But they get involved because they have a whole different battery of tests that we could go into, but honestly, we would, at that point, people would probably fall asleep if they haven't already. But the first thing that even an officer at roadside is going to check for is going to be the what's called vertical nystagmus. So that's where he positions the stimulus here, and he's moving it up and down. And so if someone observes, or if an officer observes vertical nystagmus, that is an indication of either intoxication by drug use or very, very high alcohol intoxication relative to the person. Because we all know, from going to the family cookout or whatever, that different people have different tolerances for alcohol. And again, what may be a lot for one person may not be a lot for another, but if the officer observes a vertical nystagmus, he or she is going to indicate that on his or her report, and then they're going to look into the possibility that the person is intoxicated by another substance other than alcohol, or by a combination of alcohol and other substances. But you mentioned things like weed, cocaine, methamphetamine, heroin. Those substances have a very specific shelf life, if you will, or a very specific time that they are active in a person's system. Some of them very short, some of them 5 minutes, 15 minutes, things like that. And so, but you can, marijuana or cocaine or whatever it may be, it's going to show up in your blood and urine long after you have, long after you're high, if you will. You've already come down from your high, but those substances are obviously going to be in your system for days, maybe weeks, maybe even months sometimes, depending on the substance, and also how they're checking for the substance as well. And so then you're going to have to look at, okay, officer, what the reactive time or how long this substance is active in a person's system? No, I don't necessarily know. I don't really know that. And so that's where, if you know who your DREs are, and you know that a DRE was not brought in on your client's case, but the officer said, oh, he is high on marijuana, and I'm giving him a DWI. Okay, cool. What do? Instead, if we're taking the case to trial, I'm just going to subpoena a drug recognition expert. And I'm going to get somebody to commit, the arresting officer, to commit to a timeline. And then I'm going to bring in the drug recognition expert who works for the state, and I'm going to have him read from his training manual about the reactive time and the time that marijuana is active in your system. And we're going to create reasonable doubt, because essentially the prosecutor and the arresting officer are asking the judge, or possibly the jury, in Louisiana, misdemeanors are tried by a judge only. So if you hear me referring to the court or to the judge more than the jury, it's because the majority of DWIs are misdemeanors, and all misdemeanors in Louisiana are tried by judges. With that out of the way, I'm basically at that point, I'm going to point out that, hey, Your Honor, or ladies and gentlemen of the jury, the state of Louisiana says that my client was intoxicated with this substance. Now, you heard from someone who is a drug recognition expert, someone who wears a badge, someone who wears a uniform, just like that officer that the state called. The person I called wore a badge, had a uniform, went to more training than that officer. He says that the window for this actually showing positive in your system is this big, but the window for it being active in your system is this big. And ladies and gentlemen of the jury, or Your Honor, the prosecutor wants you to believe that the officer just so happened to arrest him in this window. Not this window, not this window, not this window. They want to shut the window. Or maybe it's more like, I want to shut the window. I want to shut the window on this. Do you believe that the officer could have pulled over, made an arrest, got him to the station, drew blood, taken urine, etc., inside of this window? Or did they just get a positive result because the window is actually this big?
Wow. Powerful. Wow. Are there differences in penalties when it comes to first offense, second offense, or third offense?
Absolutely. So, and we already kind of touched on the revocation of driving privileges in the state of Louisiana, just like any other state in the union. Driving is a privilege. You're not entitled to a driver's license. You have to, prove that you're responsible and able to operate a motor vehicle in order to get one and know the rules and laws of the road. And if you're arrested for a DWI, there are consequences just for being arrested. The implied consent law, things like that, those are civil penalties. And those are handled by an administrative law judge over the telephone and through some emails, whether or not you continue to have your privilege to operate a motor vehicle while your DWI is pending. And you're going to face that just by nature of being arrested. So that's case number one. And a lot of people may not understand that whenever you get arrested for DWI, you automatically have two cases. You don't have just one case, you have two now. And so you've got this implied consent, administrative, civil law stuff going on over here. Civil case going on over here that you may not even really know about. But then, yes, there is the criminal case, the real meat and potatoes over here. And that's the one that affects more than just your right to drive. That affects your finances, that affects your freedom, that affects your ability to go freely from one place to another, outside of a car, because, again, you are facing jail time. In the state of Louisiana, a first offense DWI exposes you to a maximum fine of $500. A maximum fine of $1,000 and 6 months in jail, along with at least 32 hours community service and at least a completion of a driver improvement and substance abuse class. Whenever it comes to your second offense DWI. Now, mind you, a first offense does not carry a mandatory jail sentence unless you blow a 155 on the intoxilizer or higher. When it comes to your second offense carries with it a mandatory 2 days in jail, up to 6 months in jail. And then this is the real kicker, is remember in our DWI 1, the minimum or honestly typical sentence is that you complete 32 hours of community service, at least 16 of which must be trash detail. 32 hours, 4 8-hour days, less than a week's worth of work. A DWI 2 carries with it, again, a mandatory 2 days in jail and 240 hours of community service, at least half of which must be trash detail or litter abatement. So we've gone from what was 4 8-hour working days to 30 8-hour working days. Not to mention the at least 2 days that you're going to have to spend in jail. And again, if you blow above a 155, you're going to be, again, subjected to more mandatory jail time. And then whenever you start talking about felony DWI, your third offense DWI carries with it a minimum 1 year at hard labor. Again, this is a felony whenever you get to DWI 3 in Louisiana. Minimum 1 year served at hard labor, a maximum of 5 years. A DWI 4, a minimum of 10 years at hard labor, a maximum of 40. And that is outside of the requirement to, again, do community service, to do substance abuse classes, substance abuse treatment at that point. If you're in felony DWI, part of your sentence, once you are released from prison, is going to be that you complete substance abuse treatment. So that, again, could be 30-day inpatient, could be 90-day inpatient. You could have your vehicle seized and sold at auction, and it's not to pay your fine. It's just because that money doesn't go to pay off your fine. It's just whether it's $500 or it's a $75,000 Mercedes G-Wagon. If you lose it, it's gone. Doesn't matter what it's sold for at auction. You aren't going to see or benefit from a dime of it.
Wow.
So an extreme remedy, a rarely used remedy, but still it can be a remedy or it can be a part of a sentence that a judge can impose.
Yeah. How about the suspension of driver's license? What are the differences in the length of time a license is suspended based on whether it's a first, second, or third, or fourth offense?
I wish I could give you a straight answer on those but frankly, it's very difficult for me to, because I find that the state of Louisiana and the Department of Public Safety and Transportation, for some reason, I cannot get a consistent answer on this. The book answer is that your license is suspended for 1 year. That's by the book. But I have clients that never get their license suspended. I have clients that get their license suspended immediately. I have clients that only need to get an Intoxilock to get a what we'll call, to make things easy, a hardship license, so we don't have to get into the weeds. They only need an Intoxilock to get a hardship license. Some clients only need SR22 insurance, a special kind of insurance, to get a hardship license. Some clients have to get both and prove that they have both for 3 months or 6 months or whatever it may be, for them to get their license restored. So the fact of the matter is, I wish I could give an across-the-board answer. When this happens, that's going to happen every time. Frequently what happens is that a client is going to be without a license altogether for at least 30 days at some point in their while they're on the path of getting their DWI resolved. Okay, and I'm not talking about whether it be found guilty, pled guilty, found not guilty. At some point, they're going to be without a license, and it's probably going to be at least for 30 days. Okay, and then they are going to be told that they need to get an Intoxilock or SR22 insurance or proof of, or both, and provide proof of install to the DMV, and they will issue them a what we'll call a hardship license. It's technically a license with an endorsement. It doesn't have any necessary restrictions other than you just can't operate a vehicle without an Intoxilock and SR22 insurance. But that's getting into the weeds a little bit.
Okay.
Yeah. So that you are going to face a license suspension. There's no doubt about it. The question is that are you going to be without a license for 30 days, 90 days, or 365 days? Are you going to have to get an Intoxilock, SR22? I hate to say it. Those seem to almost be a case-by-case basis because the result is woefully inconsistent.
Thank you. Is Intoxilock and ignition interlock the same?
Yes. Whenever I say Intoxilock, I think that's maybe the trade name for ignition interlock systems. Yes.
Okay, and what does that mean for those who don't know what those terms stand for?
So, an Intoxilock or an ignition interlock system is a handheld device that before your car will ignite, you have to provide a clean sample. So that means before you start your car, you have to blow into this thing that looks like one of those like TI-83 calculators from whenever we were in high school. That really big calculator. That is wired into your car. Or into your ignition system, into your steering column. And before you do that, it's this big handheld unit, and it has this little bitty straw on it, and you blow into that, and if you come back with a clean result, it lets you start your car. Nowadays, if it comes back with if you blow hot, for lack of a better term, if it detects alcohol in your system, number one, it's not going to let you start your car. Number two, it's actually going to send that result to potentially DMV, the prosecutor's office, your probation officer. We can go on down the line who could get notified of those things if you blow a hot sample, if you will.
Okay, thank you. And what is SR22?
SR22 is high-risk insurance. It is a type of insurance specifically for people who have been accused or convicted of a DWI. So high risk and high cost.
And how can people contact you?
So the best way to contact me, if it's for DWI, it's going to be WhiddonLawOffice.com. You can go there and get in touch with me. You can also call my phone number, 318-387-2776. That is our phone number. And we answer the phones 24 hours a day, 7 days a week. Someone is going to be there to pick up the phone and schedule the appointment for you, take your case information, and get you in touch with us or with me as soon as possible, as soon as my calendar will allow. And then other ways, we are on Instagram, WhiddonLawOffice.com. We are on Facebook, Whiddon Criminal Defense or Whiddon Law Office. And then whenever it comes to the expungements, that's real easy, erasemyarrest.com. You can also follow me on TikTok. I've more or less merged operations on TikTok because my profile picture on TikTok is going to be the Whiddon Criminal Defense logo. It's going to be the bird that you saw in the promo video. But when it comes to our my handle on TikTok is Erase My Arrest.
Erase My Arrest. Thank you, Kit, for coming on Legal Angle. It's been a pleasure talking to you for almost an hour now. And I want to ask you, what does it mean for you to come on this show to educate our audience?
Well, so I want more than anything, there are a few things that I want people to know. And it's that you have rights, and you should not be ashamed to assert them. Looking at you, Emmanuel, you are literally the American dream. You came here without a dollar in your pocket, and you have been wildly successful because you had determination and a dream. So you had faith in yourself. And if we want to make it biblical, not that I'm a particularly religious person or not, but you had faith in yourself and you went to work. Faith without works is dead. And you said, no, I have faith in myself and I'm going to go to work. You know and respect what the state, what the United States and what the Constitution is about. And it doesn't matter if you're in Ohio, where Emmanuel is. It doesn't matter if you're in Louisiana, where I am. It doesn't matter if you're in New Jersey, New York, California, wherever you may be. The United States Constitution and your state's Constitution protect you. They are there for you. And it doesn't matter what the nice or not so nice officer is saying. You can assert your rights. You can refuse roadside test. You can refuse the intoxilizer. You can refuse to make a statement. You can request to have a lawyer present if you're being questioned. You cannot refuse lawful commands. If an officer asks you to step out of the car, that's a lawful command. Step out of the car. But if an officer asks you, where are you going, where you been, who you been doing it with, I'm sorry, officer, I don't feel like discussing my day. It's a perfectly reasonable answer.
Thank you.
You do need to give the officer, if he asks for your name, identifying information, give him your identifying information. But other than that, assert your rights. Assert your rights to a lawyer. Assert your rights to not be searched and not have your property searched, including your person, your vehicle, your cell phone. Assert your right to not have those things searched without a valid warrant. Assert your right to not consent to a blood draw without a warrant. Assert your right to not give a urine sample without a warrant. Assert your right to refuse the intoxilizer. Don't get me wrong, your mileage may vary by state. Different states have different rules about implied consent law, and there are even it's even a potential criminal penalty in some states, including Louisiana, to refuse the intoxilizer. In the state of Louisiana, if you refuse the intoxilizer so many times, that itself can be a criminal penalty. But what that machine and what that officer are hoping that you're going to do is to become a witness against yourself. And the United States Constitution says that under no way, if you're facing criminal charges, do you have to be made a witness against yourself. So if you are in the 50 states of Louisiana, assert your rights, comply with lawful demands or lawful commands, but otherwise, assert your rights. Know your rights, assert your rights. Do not be a witness against yourself.
Thank you, Kate. And thank you for coming on the show once again. And for those of you who are listening to us either on your phone, watching us on your computer, or just listening to this as a podcast, you heard it from the expert. Assert your right. When an officer asks you, have you been drinking? You don't have to answer that question. Don't incriminate yourself. And we thank you for your time. We thank you for joining us on this show. Until next time, stay blessed. And don't forget to subscribe to our YouTube channel, Facebook, and also on Instagram. Thank you. Bye for now.